And away we go. Hello, and welcome to another edition of The Sit Down on the College Football Mafia Network. I'm your host, Nathan Bomber Brown, and with me tonight, I have a guest host. That would be Rec Talk, back in the house in the middle of the week. Thanks for being here, Rec.
Yes, sir.
And then we have a special guest tonight. That would be Ryan P. Mulvaney. I want to make sure he is a shareholder at Stevens and Lee Private Company. Is that what PC was?
Professional corporation.
Professional corporation. See, my memory's like that long. I'm sorry, Ryan.
No apologies.
We appreciate everybody being here tonight. We're going to be talking about all legal troubles associated with the NCAA and all the players, the unions, whether there are unions, and what can be done to fix this thing that's called college sports. And so we appreciate everybody being here with us tonight. Make sure you follow all of us on Twitter. You can find Ryan it's Ryan P. Mulvaney on Twitter. And then everybody knows Rec Talk. They can find him on there as well. And last but not least, all my call signs there you see underneath my face. Before we get started, I want to give Ryan a chance to introduce himself, tell us a little bit about what he's doing and why he wants to get into this sports stuff.
I've been into sports stuff for a little while, but first of all, Nathan and Rec, thank you both for having me on. I very much appreciate it. So I have been a practicing lawyer for probably 22, 23 years now. Practiced commercial litigation, so I cut my teeth in the courtroom. Federal state court in New York, New Jersey, Pennsylvania, Connecticut. Handling all sorts of civil and, in some cases, white-collar matters. I've had the opportunity in 2016, at the encouragement of some of my old alma mater basketball players from Seton Hall, who encouraged me to become certified by FIBA, the overseas governing body of basketball. And then in 2018, I became certified by the NBA Players Association to be an agent there. So I've represented athletes at least since 2016, and unofficially as just a lawyer prior to that. So I've although a practicing lawyer, I've been involved in sports law for quite some time now. And obviously, all the things going on in college sports, NIL, revenue sharing, and even including NCAA investigations. So I've represented NIL collectives in NCAA investigations, student athletes, which we'll get to that term in a bit.
Yeah.
I refer to them as athletes or college athletes, not student athletes like the NCAA and some of the conferences do. But I've represented them throughout some NCAA investigations. And obviously, I do work with athletes in the NIL and revenue sharing space.
As everybody's watching right now, I appreciate you put your comments in the comment section. I'll try to get to as many of those as I can. We do have limited time tonight, so if you want your question to be sure asked, make it a super chat. Otherwise, we're just going to go forward with what we've got. I think it's a good pool of questions, and I hope Ryan is patient with us tonight. Really quick, Rock, are you hearing feedback, or is that just me?
I am as well.
Okay. Let me see. Don't do anything. Let me just check the connections here. Give me a second. Okay. So Ryan, that's on your side. Do you want to connect again?
Sure. I'll disconnect and reconnect.
That'd be great. No, hey, don't worry about it. We got time. While he's doing that, I want to thank everybody again for being here. Make sure you guys are considering becoming members of the College Football Mafia Network, or super stickers are also available, not just super chats. So it's really important that we give people opportunities to be involved, and that's really where we're at. To be involved, that's the way you do it. I'm going to disconnect his session, and he'll have to come back. Rec, yeah, I assume you've got questions. What's your number one question that we could ask Ryan?
Oh, I have a ton of questions. So, we were talking beforehand a little bit. One, something that I brought up even before then on my own channel is how taxes work for these student athletes. I imagine it would be very easy if you don't have the right people around to get in a pretty nasty tax situation. So if you guys don't know the state of Georgia, I don't know if they just passed it or they presented a bill to basically exempt NIL money from state income tax, but then you play in all these different states. So I'm not exactly sure how that works. We got Ryan back now.
Yeah, we do. Ryan, can you hear us?
I can. Thanks. Sorry
All
about
right.
that. A little bit better.
Much better. You
All
sound
good.
really, really good now. Rec, why don't you go ahead and finish that question for Ryan?
Yeah, in the state of Georgia, like I'm here in Atlanta, I don't know if they've passed the bill or they presented a bill that exempts NIL money from state income tax. But I know, like in the NFL, those players pay state income tax in every state they play.
Yes. Yep.
So can you kind of enlighten us on, like, is it similar for college athletes, or how is that going to work for college athletes with like their tax burdens?
So it's still evolving, to be honest. Look, I think college athletes, one of the biggest discussions I have with college athletes is, particularly now when they sign an NIL agreement or when they sign an MOU, memorandum of understanding, for purposes of revenue sharing, you're now a professional, right? You need to save your money. You need to pay your taxes. Now, the NBA, the NFL, as you mentioned, has, or not has, but the IRS taxes professional athletes in each state. The states tax as well, right? So they call that the jock tax. If I represent somebody who plays for the Knicks and that athlete goes to California or goes to Utah, practices there, plays the game there, the state of Utah, the state of California can share in the taxes that the athlete must pay. Here, look, athletes should certainly withhold. They should certainly be prepared for a tax bill. I did see Georgia's activity. I haven't taken a deep dive into it. As I understand it, I don't know if the governor has signed it into law yet. I know there's certainly some movement there, and that it would exempt NIL compensation is interesting, right? So what I'll say to that from a recruiting perspective, if you're a school in Georgia, now you can exempt NIL payments. Those student athletes, they don't have to worry about paying state income taxes on that NIL payment. It's not a bad recruiting tactic.
Right.
I would expect, I would think, at least other states would fall in line and do the same. But yeah, it's an interesting concept, certainly. We'll see what happens along the way with the state of Georgia, and then we'll see what happens with other universities. With other states for those NIL payments.
Yeah, and I kind of had a follow-up to that because, and look, I'm just a lay person, a fan with what I would hope to be common sense. We'll see tonight. How is NIL money even defined? Because when this came out, it was supposed to be endorsements from like businesses, if I'm understanding that right. Now we know it's not being used that way. So
now it's more pay for play, literally.
Right.
Yeah.
What is considered NIL money and beholden to whatever rules or not, and then what isn't, if that makes sense?
Yeah. So originally, look, I'll take it back a little bit farther than that. You have high school players who already have a brand before they're even recruited for college, right? Mm-hmm. A lot of the kids. Look, I operate as an agent in basketball. As a lawyer, I represent college athletes across the sports. If anyone has paid any attention to basketball over the last, say, 10, 15 years, everyone has heard of Jelly Fam. A group of kids in New York all went to D1 universities. Most of them are playing pro right now. Everybody who paid even just a bit of attention to basketball heard of Colleges were recruiting the male and female players in Jelly Fam. They couldn't earn any compensation, right, based on what they had established in high school. Millions of followers across the board for these young players. So fast forward, we have the advent of NIL. And yes, it was supposed to be for your name, image, and likeness used by, say, companies sponsoring an athlete because that athlete has millions of or hundreds of thousands or even thousands of followers on social media, what have you. It's turned into a little bit of pay for play. I think the NCAA's rules against pay for play, I mean, it is what it is. The schools and collectives, which are obviously the group of alumni who form NIL collectives for the singular purpose of compensating an athlete for their name, image, and likeness to attract them to go to a certain school. That's what it's turned into. And look, I operate in this circle, not as an NIL agent. That's not what I do. I operate as a lawyer in the industry. And I've worked with a few NIL agents over the past couple of years. But it's taken a little bit of a turn. It was intended originally for, let's say your local car dealership to compensate an athlete either monetarily or in kind by the use of a vehicle, and then that athlete goes on social media and says, "Look, I got this Range Rover from the local Range Rover dealer.
Exactly.
I get all my Range Rovers from said dealership." But look, it is what it is. Collectives have, and I represent some collectives. Some of them have laudable purposes, right? They do things the right way. The most important thing for an NIL collective, since we're now kind of taking a dive into this, is that you cannot compensate somebody for doing nothing, right? They must perform services under your NIL agreement for payment to be exchanged. But yeah, Rick, you hit the nail on the head. This is kind of taking a little bit of a turn from its intended purpose to what it is now. But at the end of the day, the athletes are the revenue drivers, right?
Yes.
Look, am I going to be pro player? Sure. I've represented professional athletes in basketball for years. And they're the little guy here at the end of the day.
Yeah.
They're not recruited because they get A's in history. These athletes, right? They get recruited because of one specific purpose, their skill set. Okay. So, if I come off as pro player, it is what it is. But the players are the revenue drivers, and finally they are earning or being compensated for their names, the use of their names, the use of their images, which has occurred for years without any compensation. So
yes, for sure. Before I ask my next question, I want to thank everybody for being here with us. We're 15 minutes into this thing. I hope everybody buckles up. Start putting your questions in the comment section. If you have a question you want me to guarantee read, it'll have to be a super chat tonight. That's because we have a guest. Other than that, please sit back and enjoy. And I'll try to get, Rec and I will try to get as many questions to Ryan as possible. I would just encourage everybody to make sure you follow him on Twitter and get involved with his social media, because that's really where we found him, and he does some good stuff there. My first question is about this Big Ten NIL template, right? For revenue sharing, I guess it's not NIL, it was revenue sharing that the Big Ten wrote that has since been adopted by the Big 12 and I think the ACC, maybe even the SEC at this point. Where are you at with that thing? And the idea that this was canned before the House settlement was validated. In other words, it hasn't been countersigned yet, put into actual legal sense that hasn't happened because it's not a fully vetted ruling or settlement, and how that's going to affect moving forward, because now we're hearing all these complaints from conferences crying about the fact that all the work they put in could be thrown away. Like that means anything. They put the cart before the horse on their own. Nobody forced them to get proactive, and so them sitting in their own sort of wallowing does not surprise me. So what do you think about the Big Ten thing, the idea that they would sign somebody to a contract that really has nothing to enforce?
I'll answer your question with a question.
Okay. Okay.
Right? And then I'll get into the more subs. Why do you think they did it?
I think they want control, right?
Recruiting. Well, it's recruiting and control. Sure.
Okay.
They want to be able to tell athletes, look, we have an MOU. You sign here and
Okay.
you're able to be compensated. Not yet. Down the road.
Right.
And look, it inures to the benefit of college football because the season's over. It's not going to start again until, next fall. I mean, you obviously have, spring and whatnot. But it's really the revenue driving sport that you're able to do that with. So a lot of the agreements, and I'll have to speak generally about them because there are confidentiality provisions.
Sure.
In them, at least
Sure.
the ones that I've worked on. So I'll have to, kind of dance around some of the specifics, but, my thoughts on them, look, it's a standardized agreement that was negotiated, not with the players,
Right.
Among universities and conference leadership for the benefit. And look, if you look at a standard template, it's drafted in favor of the universities, as I would suspect it would be, right? I mean, if I'm representing the universities and or conference in this drafting of these agreements, I'm going to draft them in favor of my client. Now, when I get involved and when I see them on behalf of a college athlete, there are, I'll put it lightly, some red lines that, I propose to the athletic departments of said universities. So, in one instance, I like that there is some standardized agreement because there's a lot of, particularly with NIL agreements, they're all over the place.
Right.
Revenue sharing agreements, I think a little bit easier to have standard agreements. You can have them by conference. You can have them, I would think, the NCAA could propose a form for use among all of the conferences. But I do like the fact that there is some uniformity. I mean, look, we in the NBA operate under the Uniform Player Agreement. Very few things in that agreement changes, and it's like 20-something pages long. Really, the only thing that changes are the name and the preamble.
Right.
And you go back, to the end where the exhibits are, and that talks about your compensation. Everything in the middle is standard, negotiated collectively, by the way, with union and management. So what those contracts look like, we can't change them. Like I said, the only thing that changes are the names, whether it's LeBron James or Anthony Davis, and then you go to the next to the exhibit pages, and that's where your compensation is. So I do like the fact that there is some sort of uniformity as a standard agreement. Like I said, I have substantially revised some in the Big Ten, but I do very much appreciate that there is some work toward something that's standard. And
just as a follow-up, what about the argument that a particular player, let's not use a name, X player who's going to be a freshman signs one of these agreements, which technically, at what point does it become binding? And at what point, say they never register or enroll in the school, should they still be held accountable to those grants of their intellectual property even when they leave the school? How does that part has been a mess?
Yeah. So, I guess a couple of things there. Obviously, to be eligible for a revenue sharing agreement, you need to be enrolled
Right.
at a university, and in some cases, you need to be in good standing at said university. That means both academically and athletically, but it's not pay for play. So the irony there. But if you're a freshman and you sign an agreement, so let's use football by way of example, because that's really what's going on now. I mean, talking about really like college basketball for next season, that's too hypothetical. We'll deal with college football. So you as a college football transfer or freshman can sign a memorandum of understanding today.
Okay.
That becomes effective down the road in the future at some date set forth in the memorandum of understanding. Some are July, some are the last day of June, and some are when the House case obtains final approval by the court.
Okay.
If and when that comes. But the agreement, to my argument, would not become binding, right, until the conditions precedent under that agreement have occurred, i.e., House gaining final approval.
Right.
Because all of these agreements are contingent on that. And if that doesn't happen, there's nothing binding.
Exactly.
We kind of touched on the mess of it all. Obviously the Xavier Lucas, situation, with Miami and Wisconsin. At the end of the day, if a player decides to enter his or her name in the transfer portal, the school has to, within 48 hours, business days, 48 hours, has to enter the athlete's name in the portal, right? There's no qualifications in that.
You can't hold back. There is no ability to restrict that player's movement.
Yeah, so the theory of, I suspect there's tampering going on, any university could say that.
Right.
And any university could unilaterally declare or decide that we're not going to enter a name in the transfer portal. A lot of universities lose, top players. My own alma mater lost, two very good men's basketball players to other universities at the end of last season. It is what it is. This is, I mean, look, some fans like it, some fans don't, understandably, because it's the era of free agency in college sports.
Right.
The agreements, getting back to the revenue sharing agreements, they're contingent on House. Most of them are not effective until July. If a player decides, the heck with it, I don't want to stick around, I want to, enter my name in the transfer portal or disenroll from the university, as we saw, then it is what it is. The agreement terminates, and there's no obligations owed by the player, and there's no obligations owed by the university.
Okay.
Now, look, if I represent a college athlete who's gotten 50% of the payments under the revenue,
right, that's the follow-up question.
Yeah, and not the other 50%.
Yeah.
In that instance, look, and I've seen agreements that say you've got to return money, whether it's to a collective or revenue share.
Right.
If you have performed services, you're entitled to payment for those services, right? If I, as a lawyer, litigate a case to the end, and a client pays half of my fee and doesn't want to pay the other half of my fee, I didn't do half the work.
Right, you would sue him for the balance, right?
So a college athlete, same thing. If they performed the entire season, they're due all of the money under the agreement. If they decide to transfer at some point within the portal or disenroll from the university, look, it's going to be a hard charge for an athlete to say I'm due the entirety of the money.
Right.
Because I'm no longer performing services for either the NIL collective or the university under the revenue share agreement. So, but that being said, they should still be able to retain the monies that they have been paid, right? They perform services up until they decided to disenroll or transfer. They should be able to keep that money.
All right, Rec, we've got a super chat, and then I'll ask you your next question. FF18 Buffs, who happens to go by the name of Fergie, friend of the show, $5 super chat, a wonderful member as well, says, will programs remain inside ADs or better for them to be public-private partnerships outside the school? And then he follows that up with more flexible to funding Title IX.
Great question. And what I take from that question are a couple of things. Obviously, the Title IX issue with respect to revenue sharing, but also, and as I understand the question, whether athletic programs will remain parts of universities or will they go out and become private entities, quotes, of their own. Very, very interesting question. I'll take the latter half of that first, the Title IX issue. There's a lot of stuff going on now, with revenue sharing and Title IX. You've seen a lot of commentary about it. Obviously, the Department of Education, right before the swearing in of the new presidential administration,
right?
Obviously, it came out with its own interpretation or guidance on what Title IX means with respect to revenue sharing. Obviously, the administration has changed, so who knows what will now come of that guidance. I know schools were gearing up for, particularly those with football programs, to give the lion's share of the revenue share to football, and then second to that, men's college basketball, and then you go from there.
Yeah.
And at non-football schools, like Big East schools, and I suspect those who were contemplating to opt into the settlement would be doing the same thing, right? The quote unquote revenue driving sport is men's college basketball, so the lion's share will go there. Now, the Department of Education has said, no, it has to be shared equally. So revenue sharing monies must be split equally among all of the sports at the said institution. I don't really have an opinion on that one way or the other, although I will say it's my understanding that, and this is probably a very general statement or general understanding of Title IX, but without getting real deep into the specifics, because I would put your audience to sleep, I'm sure.
Okay. Okay.
But generally, Title IX says that there must be proportional opportunity. And to me, that very basic phrase means the same opportunity to earn revenue sharing dollars. Right. Does it necessarily mean because the men's football program at Miami gets a certain amount, then so too must another sport? That's hard for me to put. And look, I'm a pro player person, but that's a little hard for me to wrap around. If I had to, I certainly would. But look, at the end, my law firm, for example. Now, we obviously don't get federal funding like universities do, but if I bring in, $2 million in origination of business, and my colleague brings in $10 million of origination of business, and my other colleague brings in $500,000 in origination of business, we may all be salaried the same, but our year-end compensation is going to reflect our productivity. And part of our productivity is the origination of business.
Right.
So For Title IX, obviously it's handled a little bit differently because we're talking about federal dollars going to universities, and there's some issues there. But it remains to be seen. Maybe the guidance from the Department of Education will be revisited now that there's a new administration. And I know that was a long answer, but I'll dive into, unless you have a follow-up, the issue with private.
Yeah, go ahead. Yeah, go ahead and answer it.
That'd be a really interesting concept. And look, I'll be frank, I haven't really thought that through in its entirety, but I would have to think that if a university football program disbanded, for lack of a better term, with the university and went off on its own, could it enter into license agreements with either that university or other universities? I mean, now we're getting into what university is going to pay X athletic program the most money.
Exactly.
So,
yeah,
very interesting question.
I like that this is an evolving field that we're talking about here, right? A lot of this law still has to be made.
Yeah, look, and that's part of the fun of it is that it's ever moving. It's fast paced, and it finally, right? I mean, we had decades of it just being the same thing. Athletes be damned. So now we're a little bit now the playing field, I'll call it, is a little bit even.
Rightfully so. Go ahead, Rec.
Yeah, that leads into my question. Like, I'm in the technology field, and it seems like a lot of times when you see new technology, the law lags behind that. Like drones would be an example. Like, is it legal to fly your drone and look in someone's window? I don't think there's law that says you can or you can't. And that seems to be the case here. And I've talked with players' parents before, and I asked them, one of them, like, well, what prevents a player from getting into one of these agreements and just giving the middle finger to the school and leaving with that money? And equally, what prevents the school? Because we've seen this happen. This happened with Texas A&M, or there's rumors of this happening at Texas A&M. There's current litigation between, the Rashada kid that was at UGA suing the University of Florida, I think, and that coach. So I guess my question is, how legally binding are these contracts, or how enforceable are these contracts really?
Well, which contracts? NIL agreements?
Yes.
Yeah, and I asked that because there's, we obviously have NIL and we have revenue share. The NIL agreements are enforceable.
Okay.
Right. So long as, they're not for an unauthorized purpose, right? I mean, most states have statutory authority that says NIL agreements cannot be for X, Y, and Z, right? So you can't have an NIL agreement for an athlete sponsoring an alcohol brand, right? So no Grey Goose, no Budweiser, no Hennessy, no, name your vodka. You can't have NIL agreements for adult entertainment, right? So no.
What about gambling?
Or gambling, right? Okay. So you can't have casinos endorsing athletes, or OnlyFans endorsing athletes. I mean, the problems there are obvious. But so long as the NIL agreement does not touch upon those prohibited activities, and the athlete performs the services, the athlete should be paid for those services. They are enforceable. Look, the coach at Florida State, as I understand the news reports, I don't have any firsthand knowledge of it, but the news reports suggest that he was, making promises that athletes were going to be paid a sum certain by the collective, and that just didn't happen.
I think it was Florida.
Yeah, Florida. Look, I will say this because I've encountered this, before. NIL collectives, it's tough to raise money, right, for certain programs. I mean, my own alma mater struggles here and there. But if you're going to make a promise to pay an athlete a sum certain under a contract, and you execute that contract, you damn well better have the money to pay the athlete.
Right.
Yeah.
Plain and simple.
All right. Very good. Another super chat coming from Daniel Gygax. He's a contributor for our channel. We really appreciate him, and he's a paying member, which makes it even better. Will the House settlement cause universities to drop to Division III where there are no scholarships, or drop athletics altogether? And then he follows that up with, especially where schools are currently tight with budgets.
Sure. Look, and no one wants to hear that, but I think you'll certainly see activity among athletic departments, right? Some of them may drop down conferences. Some may drop down, say from the Big East to the A10. Some may go from, D1 to D2. That's certainly a possibility. And look, a lot of these universities, to the extent they opt in, right? So I'll get into a little bit of a boring legal analysis here, but universities, to be bound by the House settlement, would have to opt in.
Yep.
Okay. So revenue sharing, that is, right? This revenue sharing aspect, universities would have to opt in to this concept. Some are choosing not to do that, right? You see the Ivies, right? They're not engaging in the revenue sharing. Other universities may not do the same. A lot of the smaller universities, may struggle to if they were to opt in. It's a school by school decision, so it's not conference based. So your alma mater will make its decision separate and distinct from any other school within that conference. Okay. So I look, it's unfortunate, and you see now athletic programs being cut as it is, without the revenue sharing hanging over their heads. So some of the programs are being cut. A lot of athletic departments are declaring some to be revenue producing and others not to be revenue producing. You see a lot of athletic departments now publicizing that they lose money on an annual basis.
Right. And that used to be something they used to hide. And now they're basically going out and saying they can beg for more money because they know more money is required to participate.
Yeah. Yeah. And look, a lot of the pro teams used to do that, right? Suggest that they were losing money or breaking even. As someone who's been involved in complex commercial litigation over the years and have had cases with forensic accountant experts, a lot of places that claim poverty are doing so strategically. Not to suggest that some of these schools that are claiming to lose money are doing so strategically, but there is an element of that, I think, as well.
Rec, do you have another question?
Yeah, just kind of broadly, because we went from having just stringent rules that were selectively enforced by the NCAA, like SMU getting the death penalty, doing the same things that Texas and A&M were doing, to just really no rules now. Like, you hear tampering, but you'll never hear a coach say who is tampering with their players because they're doing the same thing. Where do you see this going? And for me, it seems like you've got to start moving to an NFL type model where you have a collective bargaining agreement. Because like with the Title IX stuff, you're going to have a ton of universities tied up in litigation on Title IX issues, probably. So where do you see this generally going? What does college football look like in 5-10 years from now?
So another great question. Where are we going? And you raised the collective bargaining issue. At the end of the day, I think you hit the nail on the head where, look, if you want to really get rid of and let's not pretend that this hadn't happened before, by the way.
Yes.
Tampering, right? This is not a new thing. And by the way, neither is NIL. It's been around for a heck of a lot longer than it's been permissibly around.
Yeah, for sure.
Yeah. So where are we going from here? You raised an issue of the collective bargaining possibility. That's really a difficult question because the National Labor Relations Acts and the National Labor Relations Board, it has limited jurisdiction, right? So you're not going to have, well, let's back this up. You have what, around 1,200 NCAA programs, maybe 350, 360 D1 programs.
Okay.
Of those programs, how many of them are public? How many of them are private? How many of them are religious based? And I say all this because the National Labor Relations Act, and look, I'm not a practicing labor lawyer, but I have over my career, I have been able to touch on NLRA cases. It's my understanding that the National Labor Relations Act, and pardon me as I'm looking up because I'm thinking at the same time, it does not apply to public schools. It would apply to, private, but it's my understanding that it wouldn't apply to the I would think far many public institutions. So,
well, could colleges opt out of the NCAA? You get a new system they opt into that has a collective bargaining agreement.
I don't necessarily know if the NCAA would be the issue there. I mean, you're still dealing with a public university. Would it be governed by federal labor law? No. Could you? I think if you could probably create another version of the NCAA and have all the conferences become members and maybe come up with standardized revenue agreements, standardized, across that. But from a legal perspective, as we currently sit here, you're not going to, the NLRA is not going to come in. I'm sorry, the NLRB is not going to come in and have jurisdiction over a place like, your public institutions like West Virginia or Kansas. It'll have jurisdiction over, your private schools, Notre Dame, Fordham, by way of example, and I don't even think religious institutions. So the NLRB is not going to have jurisdiction over, say, my alma mater, Seton Hall, or most of the Big East schools, which are all, if not entirely, Catholic schools. Most of them are. Again, the NLRB and the NLRA would not apply to public schools. Could you create another, organization, and leaving aside the legal implications of collective bargaining? Could everybody get at a table and come up with a standard agreement that says we need to operate this way, and this is what our contracts should look like? Perhaps. Would that happen?
Sure.
Would that happen? I don't know. I mean, I've long maintained, and there's a dear friend of mine who is a member of I work with, I represent, who's on the coaching staff of a basketball team in college, whose name I will not disclose, but we have both, sitting at the bar, years ago, said there are a lot of conferences and a lot of universities that I think have no need for the NCAA. College football is just an entity unto itself.
Yeah, I don't even know. Yeah.
I mean, look totally. At the construct of the House case, right? P4, P5. Football is an entity unto itself. And does it need the NCAA? No, I think maybe the NCAA needs college football more.
I think the NCAA needs the entity itself to run. The entity doesn't need them, I don't think. I got another follow-up here from Rock and Rant, another contributor on the show, talking about that Big Ten template. He's asking, let's see, your thoughts on the school having at their discretion the ability to reduce payments to a player. In other words, once it's in the contract, shouldn't they have to pay what's in the contract, and vice versa? Whatever's in the contract, they would need to fulfill in the contract.
Yeah, look, this all comes down to, in my opinion, negotiation, right?
Okay.
If so, as I mentioned before at the intro, I represent college athletes. I also provide legal services, and I get engaged by not just individual athletes, but also some NIL agents to take a look from a legal perspective of what these agreements say and what they should say, at least on behalf of an athlete. Because I mentioned before, these standard templates are obviously drafted not by athletes and without the athlete's participation at the outset.
Right.
So, the reduction in compensation, on what basis? The player is injured? Well, this isn't pay to play. I mean, it specifically says that in the agreement. Now, that's the only thing I'll say about specifics, but this whole notion of, athlete compensation is somehow not tied to athlete performance is just, it's pay to play. Let's just call it what it is. This comes down to negotiation. I mean, I would redline that to no end and to try to protect my player. If my player or the player that the NIL agent directs my way for legal services, I would try to protect the player as much as possible. On what basis are we reducing the compensation?
Yeah.
On what, whether is it injury? That can't be. I mean, there should be some injury. There's injury protection in the NBA.
Right.
Yeah.
Right. So, I not only bring, the 20 plus years of lawyering to the table, but I also bring, thankfully, my experience with the NBA to the table. And look, that applies across the board. If a women's volleyball player were to receive a standard template from, Big Ten or name the conference, I'm going to do the same thing that I would do for a college football player or a men's basketball player or, a women's swimmer. If it's a standard agreement, a revenue share agreement, then it needs to be reviewed. It needs to be, in my opinion, revised in favor, or as much as you can, in favor of the athlete. And look, the athlete can make the decision, based on the language of the agreement and said university's refusal to amend it.
Right.
I think I'll go over there.
Yeah,
that's right. Yeah, they could say we don't want to do this anyway.
Yeah.
Yeah, nobody's forced them to commit. That's true.
No. But the reduction in compensation. Look, if you've performed and if you earned the compensation, pay the compensation. Plain and simple.
We've got just a few more questions. If you want to get your question in, now's the time to make it a super chat, and we'll try to get it in before we let Ryan go. We'll shoot for about 10 minutes or so left, so you have that time. If you want to do any more super chats, now's the time to do it. Rec, one more question from you.
Okay, yeah. I'm just looking at trying to get, I think we can all agree this isn't manageable for anybody, the player, the school, the NCAA. The NBA and NFL enforce rules all the time. Why are they not getting sued into oblivion? Is there some arbitration agreement that they'll go to arbitration before they want to litigate something? Or why is it so different for them?
Well, it's the CBA, right? The protection.
Yeah. So there's collective bargaining in both of those sports. The NBA has a collective bargaining agreement that's negotiated, between management and the Players Association. And it provides avenues to resolve disputes within the agreement.
So you just can't, when you enter that agreement, you can't enter litigation with the NBA or the NFL.
If you're a player?
If you're a player, or if you're like a team, like if you're an owner of a team. Like if I'm an owner of a team and I feel like I'm being unfairly targeted or something by the NBA, do I not have an avenue to litigate against the NBA?
Say that again, Rick. If you're an NBA owner and I'm being unfairly, if I'm an NBA owner and I'm being unfairly treated by the NBA,
right? I mean, this is what's going on in college. Hey, you can't tell me that you can enforce this fine on a player or my team. I'm just wondering why you don't see that in professional sports.
Yeah,
and how college can move to that.
Yeah, if you're talking about fines, that's all covered by the CBA. And look, if we're going to get into the NCAA, that would be something that I hate to use the phrase collectively bargained, because I personally don't know. Look, the legal hurdles to unionization in college sports across D1 is very, 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 very challenging, given some of the reasons I said before. So when I say collectively bargain, I just mean everybody getting in a room and trying to hash out, some standardized, concept of how we're going to move forward collectively. I don't necessarily mean union, although I think maybe, certain universities could probably, or conferences, try to do that. But that's where it would have to be covered.
Okay.
Just a couple more. Let's get another super chat here from Fergie. $5 super chat saying, is the NIL clearinghouse that is being proposed that has third-party accounting firm going to happen, or be, I'm going to say, illegitimate, maybe? Be legitimate. Yeah.
Fergie, I like if it's illegitimate, Fergie, I like that. I like the premise of the question. And I got to laugh out of that because, look, I'll give you my own, personal like and dislike of the House case, and getting into this, marketplace of accounting firm dictating fair market value, and clearinghouse. Here's what I don't like about the House resolution, and it kind of it corresponds to what Fergie's question is with the clearinghouse. The salary cap that was negotiated among litigants,
right?
Not collectively with D1 athletes, right?
Exactly.
So if I'm
right.
a D1 athlete at a Big 12 university or Big 12, you're limiting my ability with respect. You're effectively collectively bargaining on my behalf, despite the fact that we have no representation in terms of a union. You're limiting the amount of compensation I can make, which, by the way, is that not an antitrust violation, right? You're telling me that I can't make more than a certain amount of money.
Yeah.
So the market, the clearinghouse, I have a little bit of an issue with that too, because, who is the NCAA or who is the NCAA's independent third party to declare what is and what isn't fair market value?
Right.
If an NIL collective that I represent decides to pay X player $15 million to do two things on social media, okay, so be it. That's an exercise of business judgment by the NIL collective. Is it good business judgment? I don't know, but I'm not the one to determine that. And what do we have in the infancy of this industry to declare what is and what is not fair market value across the board for athletes? That is far too individualized, in my opinion. I think the clearinghouse, you want to have something that collects data. Okay, fine. You want to have something that collects the contracts and information, and because there's now mandatory disclosures of any NIL agreement over $600, so be it. But don't tell me that the NCAA or a wing of the NCAA or a hired third party by the NCAA is going to somehow dictate what fair market value is for my clients. That's going to be determined by the market.
Yeah, and that then you got disproportionality between the conferences. And how about the House settlement was involved 4 conferences? There's another 11 or whatever, just making up a number that weren't sitting in on the negotiations, and how fair that was. So I've only got one more question for you, and then we'll let you go this time. But you have to promise you'll come back.
I'll definitely come back. I appreciate it.
Oh, absolutely. It's been fun. Last
So long as
question.
Fergie comes back, because there's some good questions from Fergie.
Well, Fergie knows what he's talking about. He's a Buffaloes fan. So let's talk about just the House thing itself, right?
Sure.
We now know how many countersuits are ready to go the
Yep.
minute this thing gets finally signed off on. Something I've said since the day it was announced,
Yep.
that the House settlement will never 100% be fully implemented because there's so many countersuits to it. What happens the day after she approves it? Let's assume she signs it. What happens the next day, and where does the settlement go from there?
So it'll be interesting to see what she does before we even get to the execution and approval of it. As you've seen, there have been so many objections filed,
right,
by a variety of college athletes, former, current. So who knows what she's going to do? She may very well tell the parties that they have to go back and
really, even at this late date.
I would look. She can't. If the objections and/or objectors have, credible arguments. I mean, how am I as a district judge? And look, I clerked in federal district court for a district judge. How am I going to grant final approval to an agreement, a settlement agreement? Yes, I preliminarily approved it,
right?
But that doesn't mean it automatically obtains final approval.
Okay.
Okay. So she can adjourn the hearing, certainly. She could direct the parties to go back to the negotiation table based on maybe some objections that she finds to be worthwhile. And maybe some she disregards, but others, I mean, there have been so many objections.
Right.
I can't imagine she's going to disregard every single one of them. But do I anticipate other lawsuits? Absolutely. Lawsuits challenging, salary caps.
Right.
Lawsuits. Look, we've seen thus far, just since House has been filed. Look at all the cases that have been commenced.
Yeah. The ones that I think have the most value are the conferences and schools that weren't part of the negotiation.
Well, yeah, I mean, I know, and I know this from public reporting, not from some personal knowledge, but
right.
The Big East, was not entirely thrilled to not have a seat at the table. But then again, you need to look at who the parties of the case are. Right. So, I understand that some of the conferences have proposed or filed their objections. I know the House case. Look, I helped a few of the former Seton Hall basketball players process their proofs of claim. So just because the Big East and other conferences are not parties to the case, the settlement does cover those athletes. I do anticipate more lawsuits being filed. I mean, the House case may be over, but litigation with the NCAA is not.
Right.
That's for certain.
Yeah. And until they get antitrust protection, from the federal government until they actually pass a law. You're basically legislating off of lawsuits.
Yeah.
And that's crazy. I've never heard of that happening before.
But yeah, I mean, for that to happen, you need to have Congress to act. I know, look, I'm sitting in Dallas right now, looking at American Airlines Arena right outside my hotel window. So in Texas, Senator Cruz, right, is obviously engaging in this arena. You're going to need, some sort of federal legislation to resolve some of these issues, as some people argue. I don't know if antitrust exemptions will be granted. I know that's something that's being talked about and pushed. But then we get into, unionization. You get into, the public university issue. I mean, I would think, without having taken account, but I would think that there are more public universities than there are in Division I than private.
Oh yeah, for sure.
But how, if you're going to have unionization, how can you do that across the board in NCAA Division I when you have so many public universities? As I mentioned before, the National Labor Relations Act does not apply to those universities. How do you get all of those schools, public, private, religious, at the table? And look, Senator Cruz is a smart guy, clerked for the U.S. Supreme Court. So, and he was a practicing lawyer. Look, if he can figure it out, so be it. But it's going to be a challenge. I think collective bargaining is going to certainly be a very, 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 very steep uphill battle. And I do, as I mentioned before, anticipate a number of lawsuits being filed, whether House is finally approved or not.
Okay, that's kind of what we expected too. Ryan P. Mulvaney, thank you for being here. Why don't you tell everybody where they can find you and what you do, and try to drive some business your way.
Sure. Well, feel free to look. Hey, Fergie, by the way, if you have any other questions, feel free to send them to me over Twitter. I enjoy the dialogue, not only here, but also on Twitter.
Right.
I very much enjoy talking about these issues. It's not, kind of mundane, complex litigation. So it's fun for me. I mean, look, I got into this because I have a love of sports, just like you guys do, and a lot of your followers do. So, certainly, if you'd like, follow me on Twitter. My law firm, I guess, is ticking underneath there. So if you're a college athlete or an NIL collective, feel free to reach out. Would love to have a conversation and be able to help.
Well, we appreciate you being here tonight. Rec, any final words before we get out of here?
No, just thank you so much for coming on, man. I learned a ton about this. There's a reason I'm not a lawyer. I like clear-cut things, and nothing about the law seems all that clear-cut.
No, it's not. What they say, if you really want to screw things up, put two lawyers at the table and nothing will ever get done. So,
oh boy,
there you go.
I very much try to streamline that process, but I do have some good adversaries who try to muddy things up a little bit.
Well, thanks again, you guys. I appreciate both your time and coming on. That's really fantastic. Ryan, we'll get you scheduled. Maybe in a month we'll do this again. Sure. I don't want to take advantage of your time, but you see, we have the smartest fans in the YouTube verse. They ask some of the greatest questions. So thank you for coming on and doing that with us tonight.
I appreciate it. And everybody keep an eye out April 7th. We'll see whether the House gains final approval or not.
Okay, we'll point towards that and see what happens between now and then. Thanks, everybody. Everybody else, have a great night. Stay out of trouble. And we'll see you Friday night, 7 p.m. Eastern time. And that'll be our big freaking Friday show. So thank you for Ryan. We'll see you later, Rec. Everybody else, have a great night tonight. Peace out.
Thanks, guys.